Good day, everyone. Welcome to our lecture as an introduction to Philippine labor law and legislation. In this video, we will have an overview and the basics of Philippine labor law, and we will cover the following topics: basic pay, or overtime premium, night shift differentials, holiday premium, the so-called 13th month pay, the service incentive leaves, maternity and paternity leaves, as well as the parental leave for solo parents. So before we proceed with those topics, let us first touch the coverage of the labor code, which is the applicability of all of these provisions of the labor code. When we say applicability of the labor code, it covers all employees, okay, in all establishments, whether that particular establishment is for profit or not. But there are several exceptions that are not covered by the labor code. So if you will say you are part of the exceptions, the provisions of the labor code do not apply to you, right? So we are only talking about the labor code provisions in this particular video. And if you fall under the exceptions, then there are separate rules or provisions that apply to you. So who are these exceptions that are not covered by the labor code provisions? First, there will be government employees. So employees of the Philippine government are not covered by the labor code. Rather, they are covered by separate law, the Civil Service Code, and other particular laws that apply specifically to government employees. The provisions of labor code also do not apply to field personnel, to managerial employees, employees who are given managerial discretion, or positions that would affect hiring, placement, as well as firing of other employees, officers and members of the managerial staff by very nature of their proximity to managerial employees or management, the members of the family of the employer who are dependent on him to support. So you cannot, like you say, you're working for your parents with a business, but you're still dependent on your parents for support. You're basically just working there part-time. You cannot seek refuge under the provisions of the labor code because it does not, or they do not apply to you. Also, workers paid by results, persons in the personal service of another, and domestic helpers, because they are covered by separate special laws, not the labor code. So now we're clear with the coverage of the labor code. So, before we move forward, I would like to put to emphasis that the coverage of the labor code will be all types of employees in all types of establishments, whether that is for profit or not. So if you're an employee of a charitable institution, you are covered by the labor code. Okay, that doesn't necessarily be an argument that you're not covered by the labor code because we're not really profitable. We're not really distributing profits to certain individuals. We are a charity institution. No, you're still covered by the labor code as long as you are not one of those listed as exceptions. Okay? Now, let's proceed to the establishment of the employer-employee relationship, because this matters with the fact that all of this discussion covers all employees. So it is important that we establish first whether there is an employer-employee relationship. Otherwise, you're not covered by the provision because you're not an employee. So when you determine the employer-employee relationship, the most prevalent rule that is being used here is what we call the fourfold test. The fourfold test is comprised of four factors, the presence of which determines the existence of the employer-employee relationship. First will be the ability of the employer to select and engage the employee. So if the individual selects another individual from a crop of applicants and then engage the individual, then that individual could be an employer, or the hired or engaged individual could be an employee. Second will be the payment of wages. That's another factor. If you're being paid for the services you're rendering to someone else's, you probably is an employee, and the one paying you is an employer. The power of dismissal, when you're dismissed by that individual because, say, of certain infractions or violations of certain rules, or your inability to be productive, that is a factor as well. And the last one is the power of control or the control test. However, amongst all of these factors, the power of control is the most important element. This is the telltale of all the factors. If the control test is not present, there's a big chance that you're probably not an employee. So what is the control test? The control test, or the power of control, refers to the ability of the employer to control the means and methods by which the employee is to accomplish the task. Not just the end or the goal, but the means and methods by which the employee has to achieve that goal. So that is the control that we're talking about here. That was a 1988 ruling of the Supreme Court in Continental Marble Corporation versus NLRC. Absent the power of control, there is no employer-employee relationship. So this is the most important one that we have to check. So whether the work you're rendering in favor of the employer or purported employer or for someone else's, and that particular person has the ability to control your means, not only the objectives, that's why you're working. Okay, you're working because there is a goal that you have to finish or to accomplish, but the control extends to the means and methods that you're doing the particular work, not just the objectives. Then there is a power of control there that establishes the employer-employee relationship. And how do we actually distinguish the absence of power of control here? Because there are certain individuals where they're selected and engaged to work, they are paid or compensated for the services they're rendering, and they could also be dismissed or terminated from that particular engagement. But the purported employer here do not control the means and methods of working. The primary concern lang of that particular purported employer is really the objective, the goal. I just want customers to be signed up. But I don't care what method or means you're doing that, the time that you'll start your day, whether you start by 10 a.m. or 8 a.m. or whether you start late, as long as you can provide us with customers that will sign up for the services that we're offering, then you're probably not an employee there. You're probably is an independent contractor or an independent agent working for that person to secure contracts or clients. So there is no employer-employee relationship by virtue of the absence of the power of control with respect to the means and methods of accomplishing the objectives or the work to be done by the worker. So important, the fourth factor, the power of control. Now, let's proceed to the normal hours of work. Okay, so before we proceed with the basic pay and everything, let's discuss first if the normal work hours, as well as what will be the compensable hours for workers who have rendered or given their time and effort for an employer. Okay, so in the Philippines, the general rule, the normal hours of work will not exceed 8 hours. So obviously this follows the global trend where we started during the medieval period with 16 hours of work, and then the Industrial Revolution, people started to complain about being overworked, and the advent of the Industrial Revolution provided for non-agrarian undertaking or ventures, so people now started working for, like, say, guilds, merchants, manufacturing goods or products. So it went down to 12 hours, and then more activism, fighting for workers' welfare. So now we are at present, the 8 hours a day normal work hours. So the two exceptions for the 8 hours a day of normal hours will be health personnel, because there could be arrangements for health personnel where they can work more than 8 hours. Like, say, they have this separate special shift where, like, they work for 24-hour shift, and then no work the next day, and then another 24-hour work shift. So that's basically an exception to the um, 8-hour normal hours of work per day, and of course the compressed work week. We will discuss later on what's this compressed work week, but compressed work week as an overview is basically reducing the number of days in a week um, for workers, but basically the total hours per week is still the same. It's just that it's no longer 5 days or 6 days, but a much reduced number of days, like say 3 days, 4 days. So naturally, in order to have the same number of hours per week, is to extend the number of hours per day. But the workers will be working longer per day, but they will be longer working less number of days per week. So what are the rationale why we have the 8-hour labor normal hours? First is the labor code provided that it is intended to safeguard the health and welfare of our laborers, to minimize unemployment by utilizing different shifts. Because if we don't have the normal work hours, it means that you would only, like say, if we revert back to the old days where the normal work hours will be 12 hours, what will happen is you will be only hiring 2 sets of workers per shift for a 24-hour cycle. But because we have now 8 hours per day, and therefore you need now 3 sets of workers per 24-hour cycle. And because the need of 3 sets of workers per 24-hour cycle, it means that you needed to employ more people. So it, drastically reduces unemployment because it stack up per employer, the number of needs per shift. So it stack up. It's just that I need 3. It basically, you'll need 3 for each 2 workers, and it's supposed to be 24-hour cycle. So it stack up once you'll probably need say 10, or say you need 20 workers per shift. So that's basically 60 workers now, right? For a 24-hour cycle instead of like 40. So basically an addition of 20 workers. So it would reduce or minimize unemployment. And then the third is to afford employees adequate time to lead richer and more fruitful, meaningful lives, to be able to participate intelligently in public concerns. It's more of like they would have extra time now because in 24 hours, you're working 8 hours, you're left with 16 hours. So you basically can pursue now your personal endeavors, or you can contribute to public concerns and in nation building. That was the point now of the labor code. All right? So now, let's establish that the normal work hours each day in the Philippines will be 8 hours. All right? Note that there is no hard limit on the maximum of hours of work that may be rendered by an employee. However, work rendered beyond the 8-hour limit will not be considered normal. If you work now for more than 8 hours, it will now be overtime and is subject to additional pay to entitled employees. So because we have shortened the number of hours, 8 hours, and the excess of that 8 hours will then have an additional pay, which is a premium, it also discourages employers to hire to hire less people and hire just separate set of workers because it will become more expensive if you retain in a regular basis the same set of workers and have them work an excess of 8 hours, because you'll be paying a premium on their hourly rate on excess of the 8 hours, whereas if you will maintain a separate set of workers for that second shift, they're basically paid the same without the premium, right? Okay, so now let's proceed to work day. So how do we find or define work day? Work day is the 24-hour period which commences from the time the employee regularly starts at work. So an example, if the employee starts working by 8 a.m., the work day is from 8 a.m., the start of the work day, until 8 a.m. tomorrow. So it's a 24-hour cycle when we say work day. Now, we also have part-timers, those who work part-time. Under the labor code, it is not prohibited to have normal hours of work that are less than 8 hours. So it's not prohibited. It's actually allowed. The law only regulates the work hours exceeding 8 by prescribing the maximum and not the minimum. So that's the maximum normal hours that was prescribed. but there's no provision stopping employers from actually hiring or engaging individuals for less than 8 hours a day. Take note that the normal 8 hours fixed by law does not need to be continuous, okay, or to constitute a legal working day. It may be broken. Say you probably work 4 hours in the morning and then you will have an evening shift for another 4 hours and you tacked it to provide 8 hours. That's basically the normal work hours in a day. That's allowed. It doesn't have to be like an unstoppable stretch of 8 hours to constitute for the 8 normal work days. Now, I mentioned as an exception to the normal work hours, the 8-hour workday would be the compressed work week. It is a scheme where the normal work week is reduced to less than 6 or 5 days, but the total number of work hours of 48 hours per week shall remain. But in most companies in the Philippines, there will be 40 hours per work week. So you work 8 hours per day from Mondays to Fridays. Now, when you implement a compressed work week, the goal is to still have the 40 or 48 hours per week, but you're reducing the number of days that the workers will have to report to the place of business or to the office. So if it's a 40 hours per week and you wanted to reduce it to, say, Mondays to Thursdays instead of until Friday, so you have 4 days a week. So it's 40 divided by 4 days. It would mean what? The workers will then have to work 10 hours per day. Okay? So 10 hours per day, so Monday, Tuesday, Wednesday, Thursday, it's still 40 hours per week. But they're working now in excess of 8 hours per day. But that is allowed because they're still rendering the same 40 hours per week. The normal hours is increased to more than 8 hours, but make sure that the excess, meaning the increased number of hours per day, will not exceed 12 hours. In this case, in the scenario or the illustration that I have provided, the workers will still work 10 hours per day. So, well within the limitation. And then, because they're working more than 8 hours per day, but under a compressed work week scheme, the 2 hours in excess of the 8 hours there will not constitute an overtime premium. The adjustment here is it's still considered the normal work hours because they have less number of work days per week. But make sure that the compressed work week is valid in order for the employer to be exempt from the payment of overtime premium. First is the scheme of compressed work week has been expressly and voluntarily supported by a majority of the employees. But in the Philippines right now, if you're living in a massive city or an urban or urban area, traffic is like a problem. So if you're an employee, you'll probably be more supportive of the fact that you'll be working Mondays to Thursdays. So it's easy to actually get the express and voluntary support of the employees to have the expressed work week. It also lessen your expenditure like transportation, your lunch break and everything. So it's actually a win-win. Second, if the particular employer or firm or company that introduces the compressed work week is operating in hazardous conditions or may mga noxious chemicals used or substances, there is a need first to obtain a certification from either an accredited safety organization or for that particular company's own safety committee that the work beyond 8 hours is still well within the limit the levels of exposures that are set by the Department of Labor and Employment, occupational safety and health standards. Kasi diba, if you're working more than 8 hours and you're exposed to these chemicals, there has to be proof that the extended exposure of those chemicals on a daily basis are still well within the levels of exposure acceptable on our country's occupational safety and health standards. And the third here requisite is the notification of the compressed work week scheme to the Department of Labor and Employment regional office where the particular company, firm, or employer is operating. So those are the requisites. And then once you comply that one, that's a valid compressed work week. And now, while the employees are working beyond 8 hours, those
extended hours will not guarantee or will not be subject to overtime premium. But again, provided that the excess hours will not exceed 12 hours. Okay, so impossible din natin na ma-compressed work week ang 40 hours for Mondays to Tuesdays. Alright? Because if it's a compressed work week, 40 hours, then Mondays to Tuesdays, ang reporting days, then it would mean you will be working what? 20 hours per day. So that's already an excess of the 12-hour limit provided under the Department Advisory Order Number Series of 2004. Okay. Now, let's proceed to the principles in determining the actual hours worked by our employees or by the employees or the workers. Now, with hours of work, the first principle there is that all hours which the employee is required to give to the employer, regardless of whether or not the hours are spent in productive labor or involve physical or mental exertion. So, when you are asked to work, to come to the office, and then you start to time in 8 a.m., for example, while you may not be productive until lunchtime, and you started becoming productive post-lunchtime, like 1 o'clock in the afternoon, the hours spent in the workplace from 8 to 12 is still hours worked because we're not qualifying the hours being rendered by the workers or by the employees to be hours worked by virtue of like qualitative determination that it should be productive. Okay? The only thing required here is that you are required to give it to your employer. And because you are in the workplace from 8 to 12, notwithstanding the fact that you're not really productive and you're not really contributing so much to the work in the office, but you're still prevented from actually doing your personal endeavors or pursuing your personal interest because those hours spent in the office while not productive are still given to the employer, that is considered hours worked. Second, the rest period will be excluded from the hours worked, even if you're not really leaving the work premises. So, if you're given rest periods, you're allowed to rest, that is not hours worked, okay? That is excluded from the total hours worked because you are allowed to rest. Notwithstanding the fact that you can't really leave the workplace kasi it could be very far from the city center, it could be far from the malls where you can actually go and buy stuff. That is still excluded because you are left on your own devices. You're allowed to sleep, to do or to journal, to blog or everything, to scan the internet. You're allowed on your own devices. Therefore, those hours are excluded. It is enough that you stopped working. Okay, you stopped working, and second, you can rest completely, and you're also allowed to leave the workplace to go elsewhere or to stay within the premises of the workplace. It's up to you, as long as you really stop working. Okay, so that's the condition for the rest period because sometimes an employer will say it's the rest period, but that rest period is really work lunch break because you're not really allowed to actually stop working. You are eating, but at the same time there's still a meeting or a discussion and everything. That should not be excluded from your hours of work because you're not really allowed to stop working or to rest completely. Another principle in determining hours of work will be that all time spent for work is considered hours worked if the work that you're performing is necessary. Second, it benefits the employer. Third, the employee could not abandon his work at the end of the normal working hours because there is no replacement. So assuming you've completed your 8-hour work shift, but again, you can only leave if the next person of the next shift will arrive because it's essential that there is a proper turnover of, say, the machinery or the equipment. And then the person from the second shift arrived late, 2 hours late. So you were forced to actually wait there until the next shift staff or employee will arrive in order that there will be proper turnover. So the extension of the normal working hours here of 2 hours while waiting for the next shift will be considered hours worked because it is essential that there is proper turnover and you cannot really effectively abandon your work then because it is required for safety standards and everything. So that should still be considered work hours, even if technically your shift has already ended. Fourth is provided the work was with the knowledge of the employer or his immediate supervisor. The fourth principle is that the time during which an employee is inactive by reason of, like, say, interruption in the work beyond the employee's control, that shall still be considered working time if the imminence of the resumption, meaning the possibility that the work will resume, requires the employee to be present at the workplace, to stay. Say, for example, there's a power interruption. That's basically out of the control of the employee. But there is an imminent possibility that the work will resume because the power outage, the power will return sooner. So you were asked to stay in the workplace. So that the time spent waiting in the workplace for the power to come back, that's still hours worked. And second, if the interval is too brief, say it's 30-minute power outage, you cannot, the employer cannot say, we will reduce the 30 minutes from your total hours work because you're not really working because of the power interruption. But the fact here is that the power interruption is really beyond the control of the employee. Therefore, even if you're not working for that brief period of time, that's still considered hours of work because that is too brief for you to actually effectively utilize that 30 minutes for your personal endeavors. You can't really go to the mall for that brief period of power interruption to pursue your engagement because that's basically too short. 30 minutes, right? So those principles are important so that we can actually determine that that these hours, while you're not really working, that's still hours work because, again, it's not enough for you to actually gainfully be benefited from those hours or for you to utilize those hours for your personal interest or endeavors. Okay. Now, let's proceed to rules and hours worked. First rule is on waiting time. In waiting time, it shall be considered as working time if waiting is an integral part of your work. Like, say you're a company driver and you're driving the executives of the company to, like, say, out-of-town engagements, or they have a lunch out or something. While they are out there meeting people and you're waiting for them, like, say, in the parking lot or in the car, or you're basically somewhere else's, but you're just waiting for the go signal to pick them up for work, that waiting time is considered hours of work, even if you're not really in the workplace or you're not with the employer. It's because waiting here is integral component of your work. You're the company driver. You have to wait for the executives or for someone else's. So those waiting hours is considered hours of work. Second, the employee is required or engaged by the employer to wait. So you're really waiting, part and parcel of your position. And third, when the employee is required to remain on call, but in the employer's premises or so close thereto that you cannot use your time effectively and gainfully for your own purpose. So you are waiting on call, but you cannot really pursue anything because while you are on call, you are limited with that because you are within the employer's premises, or you have to be close proximity. You cannot really go, like, say, I'll go, like, say, in a different city while waiting to be engaged. No, you're not, because you have to quickly arrive once you're called to be engaged. And therefore, because you need to be in close proximity once you're called for work, you cannot really pursue it for personal endeavors or for, like, say, enjoyment. Therefore, the time waiting while on call will be considered hours of work. Okay? Take note that an employee who is not required to leave work at his home or with company officials where he may be reached is not working while on call. That's under Section 5B, Rule 1, Book 3 of the Implementing Rules and Regulations of the Labor Code. The controlling factor in this particular rule on waiting time is whether waiting time spent in idleness is so spent predominantly for the employer's benefit or for the employees. If the predominant amount of time while idle waiting to be engaged is spent for the benefit of the employer, then that particular time waiting is considered hours worked. And if the predominant benefit is to the employee then that is not hours worked. All right. Now let's proceed to preliminary and post-preliminary activities. Preliminary activities refers to those activities before work, and post-preliminary activities are those after actual work that are deemed performed during work hours and they are compensable, where the activities are actually controlled by the employer, required by the employer, and pursued necessarily and primarily for the employer's benefit. The employees are entitled to portal pay for time spent on incidental activities before or after the regular working period. Take note that the activities are actually mandated or controlled by the employer. It's not the own volition of the employee. And second, they are pursued necessarily and primarily for the employer's benefit. Because you're still staying, it's for the employer's benefit. You're staying a little bit of your 8-hour shift because the employer controlled that particular activity that you have to stay for, like, say, a closed work conference or a recap, and that particular recap extended for about 2 hours, and that's mandated by the employer can say, no, the work was already done, like within the 8 hours. What we're doing is actually just to reconcile everything so that by next day, all work is organized and everything. The employee can actually argue that no, that's a post-preliminary activity and that's not voluntary, it's not on my own volition. You are requiring us to actually stay post-shift because you wanted everything to be organized for the next day's shift. So that basically is considered hours worked, and that should be compensable. Now let's proceed to travel time. So general rule is that travel from home to work, when you're traveling from your home to the office, that's not working time. Okay? That's not considered compensable hours because you're still traveling from your home to the workplace. But that travel time may be considered compensable or hours worked if it's an emergency call and that's outside your regular working hours and you're required to travel from your house to the regular place of business or some other work site. You're already out of your regular working hours and there's an emergency and you're required to actually travel. From the time you leave your house and you reach the particular workplace or that work site, that's already considered hours of work because you're already in the comfort of your home. You're supposed to be enjoying your time and there's an emergency call. It's not a regular work hours. Second, it's done through a conveyance provided by the employer, meaning the employer picked you. There's a boss or a company service that picked you from your house for that particular extra time. That should be considered work hours already and done under the supervision and control of the employer and done under vexing and dangerous circumstances. Okay. Now with travel, which is all in a day's work, it means that the time spent in travel is part of the employee's principal activity. An example of this will be when an employee is traveling from one job site to another job site during the workday. The travel from one job site to another will constitute hours worked. An example will be in a construction company where the engineer will have to travel from one project job site and then will transfer to another job site. You cannot simply say that the time spent transferring from one job site to another will be removed from the hours worked and simply just pay the engineer and the actual hours spent on the job site, because the particular time traveling here already constitute a majority of that particular employee's work day, right? So while traveling from the home to the first workplace is not considered hours worked, it's not compensable, but the moment the employee arrives in the first workplace and would need to transfer now to another workplace, the hours spent transferring from one workplace to another, that would still constitute within the compensable hours. And then, with the employee now will travel from one work site back to the home to end the workday, that time spent traveling from that work site or job site or location back to his personal home will no longer be considered compensable hours because the actual workday has already ended. It's already travel to home. That's already a home travel. So that's not considered hours worked. Now, for travel away from home, the general rule is that when you are traveling that requires an overnight stay on the part of the employee and it cuts through or across the employee's workday, that will clearly belong or fall within the working time. And the time spent, okay, is not only hours worked on your regular work days, but also the corresponding working hours on non-working days because they are outside of your regular working hours. Traveling away from home is not considered working time. Okay, outside of those regular working hours. So, say for example, even if you're traveling, like say in Manila, you're still paid well within the working hours. Okay, but the outside of the working hours, if you say for example you're spending you go to the malls there, you visit restaurants, that's no longer considered working time because even if you're traveling, even if you're away from your home, but you're only required to work on those regular working hours, and then the remaining hours are allowed to be spent on your personal endeavors or your enjoyment, albeit the fact that it's away from your actual home. That is not considered working time. An exception will be during the meal period or when the employee is permitted to sleep in adequate facilities furnished by the employer. Now, let's proceed to sleeping time. A worker's sleeping time uh, uh, may be working. Whether sleeping time allowed an employee will be considered as part of working time will depend on the express or implied agreement of the parties. But in the absence of any agreement, it will depend upon the nature of the services in relation to working time. So the rule of sleeping time is that it's considered working time. Okay, you're sleeping there, but you're considered working time if it's subject to serious interruption. You're not really comfortable. You can be interrupted one way or another. It takes place, a sleeping time takes place under the conditions that are substantially less desirable than would likely to exist at the employee's home. And third is that it will not be working time if there is an opportunity for the employee to be uninterrupted in sleep under fairly desirable conditions. So how do we make an example of this? For many security guards who are night shift, they're alone in the warehouse or in the location and they can actually sleep a little bit, but they're sitting or they're sleeping in an uncomfortable position and they can be easily interrupted. Like say if someone's beeping in the gate or someone will wake them up to enter the facility, like from other employees who are also working night shift, then that particular sleeping time while they're sleeping, they're sitting, that still will be considered working time. Albeit the fact that some security agency might provide like rules here violate that prevents them from sleeping. So sleeping that probably is a violation of the company rules. But again, because the sleeping time there is seriously interruptible, they can't really sleep comfortably or likely in the normal condition of how we sleep, that is still considered working time. But when you are comparatively uninterrupted, meaning say for example the workers in a warehouse are tasked to wait for an upcoming shipment, but the shipment is say will arrive in 2 a.m. and they're required to stay there in the warehouse so that they no longer have to travel. They're ready to wait for the shipment to arrive. So by the time the shipment arrives, the workers are already there. So the employer asks them to actually stay within the work premises. But say, for example, they're already there 8 o'clock in the evening and they're allowed to actually sleep comfortably because they're waiting for the 2 a.m. shipment. The waiting time there is not considered working time because they're sleeping comfortably. And there is, an interruption because the expected time of arrival is 2 a.m. and they're there for 8 a.m. So that's basically around 6 hours of uninterrupted sleep. So that will not be considered not working time. So it will not be considered working time. Okay, now for power interruptions, brownouts or blackouts of short duration not exceeding 20 minutes shall be treated as worked or compensable hours whether the employees were able to use those 20 minutes productively. Second, brownouts running for more than 20 minutes will not be treated as hours worked, provided that the employees are allowed to leave the work premises to pursue their own endeavors, whether within or without the work premises or outside. And second, the employees can use the time in excess of 20 minutes for their own interests. So they're not really barred from doing anything. So while waiting for the blackout and it exceeds 20 minutes and you're out there, out and about, or you're allowed to do something productive for yourself, that may not be treated as hours worked. But say if less than 20, whether it's productive, whether you actually played basketball there, whether you've actually enjoyed, but it's less than 20 minutes, it's considered compensable hours because it's too short, okay, to actually make a conclusion that it's used for productive endeavors. Now, lectures, meetings, and training programs. Your attendance on lectures, meetings, and training programs will not or need not be counted as working time if the attendance outside of the employee's regular hours, so the attendance is actually on a Saturday or a Sunday, so you're working on Mondays to Fridays, that will not be considered compensable hours. And second, it's a voluntary attendance. You were not compelled to actually attend those trainings, lectures, or meetings. And third is that you are not required to perform any productive work for the benefit of the employer for that particular attendance, because it could be treated as like that particular attendance there for those trainings and meetings are one, if it's voluntary and you attended, it cannot be considered as for the benefit of the employer because it can be considered as your personal professional enrichment. Kasi diba, it's a skills training, you get more skills. As long as you're not really working there, something for the employer. Okay? So it's more of like your personal skill, you're upskilling. You're getting new skills or you're learning something new. And it's voluntary. So it's not mandatory from the part of the employer. Now, attendance in labor relations activities. So assuming there's a labor union in the company you're working and there is collective bargaining agreement negotiations, the attendance in those particular activities can be considered compensable if the following are present. There is an agreement between the employer and the union that it's a compensable hours if the parties in the parties' ground rules, and there is an established policy that allows for the compensability of the hours spent during the collective bargaining agreement negotiations, and it is done during regular work hours with the consent or agreement of the employer. Okay. Now, when there is a grievance meeting in the company and you are part of the union and you attended the grievance meeting, general rule, time spent in adjusting grievance between employer and employees during the time that employees are required by the employer to be on the premises of the company is compensable. So if you're an employee and you're part of the union officers and you are tasked to attend grievance meetings, that will be considered compensable hours. An exception would be is that when a bona fide union is involved and there is a CBA policy practice to the contrary. If there is a contrary practice. Now for strikes, general rule, it's not compensable. You're not compensated when you commit or you declare or participate in strikes. Exception if there is an agreement to allow a strike duration pay provided under the company policy, the company practice, or the collective bargaining agreement entered between the union and the employer. So if it allows for a duration pay, meaning like say you do strike, but under the company practice or the CBA, you're allowed to be paid for 5 days of that. So you can actually be paid if you do the strike only within that 5 days. But if they extended strike and you used up all those, what we call the strike duration pay, then the remaining excess days or the excess days will no longer be considered as hours worked or compensable hours. Now, during hearing, arbitration, and conciliation, it's not compensable because it's hardly fair for an employer that there's a fight or litigation against the employer, and then eventually the time spent of the employee filing a case against the employer would be considered compensable hours. So that is not considered compensable hours. That's hours work. Because if that's the case, for employees to actually, avoid work, I'll just sue them. And then during the duration of the litigation, like say the litigation is stretched until like say 8 months. Well, during that 8 months, I will be paid not working. Diba? So it will open for a lot of abuses naman on the part of the employee abusing that particular provision. So when you could sue the employer, the hours spent during the hearing, arbitration, and conciliation will not be considered hours worked. For semestral breaks for private educational institutions, semestral breaks of teachers are considered compensable hours worked, for it is a form of an interruption that are beyond the control of the teachers. That is a ruling in University of Pangasinan Faculty Union versus University of Pangasinan in 1993. But take note that compensation during semestral break are only given to regular full-time teachers. So part-time teachers are not really paid during the semestral break. Now, we finished hours worked. When you say working time, is one during which an employee is actually working. So it may include an instance when the employee is not actually working but is required to be present in employer's premises. And travel time, this is like a recap, travel time when beneficial to the employer is compensable. So when hours are compensable, employee is required to be on duty or to be prescribed at workplace. And then when you are at the workplace, you are suffered or permitted to work. The rest periods given to you are less than 20 minutes or 20 minutes or less. That will be compensable. And then meal periods that are less than 20 minutes. 20 minutes or less meal periods are considered compensable hours. Now let's proceed to wages. So we're finished now the hours of work and the employer-employer relationship and the coverage of the labor code. Now let's proceed now to the topic proper and actually learning about your wages as an employee in the Philippines. So wages, as defined, is a remuneration of earnings that are capable of being expressed in terms of money, whether they're fixed or ascertained on a time, task, piece, or commission basis. Meaning, you're measured by hours, so that's time, or you're measured by completion of certain tasks, or you're paid based on a piece of goods or items you've finished, or on a commission basis, as long as it's expressed in terms of money or any other methods of computation, and it's payable by the employer to the employee under an agreement. And that agreement need not be in writing. So it could be an oral agreement or a written agreement. So the compensation here, the wages are for the work done or to be done, or for the services rendered or to be rendered, and it includes the fair and reasonable value of your board, lodging, or other facilities that are customarily furnished by the employer to the employees as determined by the Secretary of Labor and Employment. So when we say here a fair and reasonable value, it shall not include the profit of the employer or to any other person affiliated with the employer. So here it's technically the fair value of the actual work to be rendered. So you do not compute here of any profit or whatsoever because you're an employee. If you will bill a particular individual for the services you've rendered and you probably factor in a lot of that money, probably is an independent contractor. Here, it's really just the fair and reasonable value of the work done, including your board and lodging or other facilities that are customarily furnished in line of your role as an employee. Now, what are the twin attributes of wages? So first, we have the cash wage and the facilities. Cash wage will be the money, the real money paid by the employer for the services rendered by the employee. And second, facilities, it refers to the articles or services that are being given to the employee and are voluntarily accepted by the employee. When we say wages, it also covers all benefits of the employees that are given under the collective bargaining agreement, such as severance pay, educational allowances, vacation accruals, mga service incentive leaves that are earned but not yet enjoyed, as well as workers' compensation, awards, and unpaid salaries for services rendered. Now, we contradistinguish wage versus salary, although we can use them interchangeably, like say in a conversation. But with the technical aspect, wages are distinguished from salary because wages, as a term, are compensation for manual labor, skilled or unskilled, that are paid at stated times, and they're usually measured by day, week, month, or season. Salary, on the other hand, denotes a higher degree of employment that are a superior grade of services, and it implies a position of office. When you contradistinguish this one with wages, that indicates a considerable pay for a lower and less responsible character of employment. Salary, on the other hand, suggests that it's a higher form of compensation and if it's a more important service. So this is the technical distinction of wages and salary, but it sounds really very snobbish and very, you know what I mean, classist. Like say, because we're more important people, we earn salary, and because really you're laborers, you will be earning wages. So that's quite uncomfortable in this particular day and age. But those were the technical distinction. But to my mind, I just use them interchangeably. Like I pay wages to office workers, or I pay salaries, but technically I use a lot of salaries. I use salaries to all types of compensation given to any workers, just to avoid this particular classist distinction that, one is more important than the other, or the other is more skilled than the other, because it denotes more importance. Like say, come on, it's 2024 already. So I use, salaries for everything. Now, we have a principle of no work, no pay. Here, the general rule is that if there is no work to perform by the employee, and then there is no fault on the part of the employer, basically it's the employee's fault, or it's the volition of the employee that the employee did not work, then there can be no wage to be paid on the employee. Because again, there's no fault on the employer. The employer did not stop the employee from working. Basically, the employer wants the employee to work, but the employee was not able to go to work, and no work was done, then therefore there can be no wage or salary to be paid. The burden of economic loss suffered by the employee here shall not be shifted to the employer. But of course, there are exceptions. Knowing that this is the Labor Code of the Philippines, this is basically a law of exceptions, the exemptions, and then exceptions to the exceptions. So the exemptions in this particular general rule is that when the laborer was able, willing, and ready to work, meaning the worker, the employee, can work, but was prevented by the management. So therefore, it's no longer the fault is on the part of the employer here. So remember, the general rule is that the employer must be faultless. So if the reason why the worker was not able to work, albeit the fact that the worker is willing and able to work, it's because he or she was prevented by the employer, he or she was locked out by the employer, he was illegally suspended by the employer, they're illegally dismissed, and illegally prevented from working, then the no work, no pay principle does not apply. So those days that are not worked are to be paid by virtue of the fact that the worker, the employee, is, willing, ready to work, but are prevented from actually working because of these scenarios or situations. So in this particular case, if you notice, illegal dismissal, if the employee was found to be illegally dismissed, notice that the employer has to pay for back wages, because the days that the employee was supposed to be absent and not working will then be considered paid, because the worker was willing to work, ready to work, but was prevented because of that illegal dismissal. So no work, no pay principle does not apply in this particular situation. We also have the equal pay for equal work principle, where the persons who work with substantially equal qualifications, skill, effort, and responsibility, and under similar conditions should be paid with similar salaries. We're not saying here that you should be paid equally, but there should be no wide gap or divide between the salaries paid when the workers or employees are actually performing the same position, they are of the same skills, they are exerting the same effort, and they are working under the similar conditions. There could be a little variation to that based on qualifications, competence, or during the salary negotiation, but there should be, like, say, we're paying double for these workers because they are graduate from this certain university, and these people from, or workers or employees from another university that are less popular, or not really known in the country, will then be paid half. That's discriminatory. So there could be a little bit of deviation in the number of salaries, because obviously in majority of companies that are without the union, the salary negotiation is by individual. You negotiate your salary as an individual. So that individual negotiation will factor in, because say for example, you have two titles, you have two qualifications, and you believe that you should be paid higher to pay for those two qualifications, then you may be able to be paid higher. But most companies do maintain, or they create this wage structure, so you can only negotiate a higher salary well within the limits of that wage structure. Because again, if you are already paid for this particular position way higher than the level allowed for the position, and then your salary is not the same salary to a position higher to you, then there is wage distortion. And you try to avoid, if you are a human resource practitioner or you're a company, you try to avoid distorting that wage structure that you're trying to maintain in the organization. Here, employees holding the same position and rank are presumed to be performing equal work. The rule of equal pay for equal work applies whether the employee is hired locally or abroad. Okay. Now, let's proceed to payment of wages. So the general rule under the labor code in the Philippines, that wages shall be paid in legal tender. A legal tender in the Philippines is in Philippine denomination, and there are rules of legal tender. You check the rules of legal tender, but as long as it's legal tender, you will be paid on that particular your wages or salaries will be paid under legal tenders. It should be in the form of cash. So no employer shall pay the wages of an employee by means of a promissory note, meaning utangan sa nako, or uutangin ko muna yung salary mo, or you will be paid with vouchers like mga SM gift checks or vouchers, coupons, tokens, tickets, chits, or any other object or incarnation other than the legal tender. Okay? The prohibition applies even if it's under the express request of the employee. Even if you request that you should be paid with SM vouchers, that will not validate that particular payment. So you should be paid, as an employee, you should be paid in legal tender, in Philippine pesos, in the legal tender currency. All right. Now, the wages, the time of payment in the Philippines, wages shall be paid at least every 2 weeks or twice a month at intervals not exceeding 16 days. The exemptions here will be on account of force majeure, an act of God, where circumstances that are beyond the employer's control, they weren't able to pay during that particular prescribed time of payment or duration of payment. The payment shall be made immediately after the ceasement of the force majeure or an act of God. Or like say there's a calamity, once the calamity is ceased, the employer has to basically pay the workers immediately. And second, if engaged to perform a task which cannot be completed in 2 weeks, shall be subject to the following conditions in the absence of a collective bargaining agreement or arbitration award. First is that the payments are made at intervals not exceeding 16 days in proportion to the amount of work completed, and that the final settlement is made upon completion of work. This usually applies to project employees, like say you're working for a particular project and the project will not be finished within like 2 weeks. It will finish in 2 years. So if that will be the case, then you still be paid with interval of what? Not exceeding 16 days in proportion to the amount of work that has been already completed. Okay? So the employer cannot claim that the project has not been finished yet. We will pay you at the end of the project, which will be in 2 years. You're working. So where were you gonna get your subsistence, your food, the payment for your rent and transportation and everything? You still have to be paid within that particular interval. Note that the interval here does not exceed 16 days, but that should be in proportion to the amount of work completed with respect to the project, and there is a final settlement to be paid to you at the completion of work or the project. Now, provisions regarding wages. First is that there is non-interference in disposal of wages. The employer should not have any say whatsoever on the manner of how the employees will spend their salaries or compensation. The employer shall not force, compel, or oblige the employees to purchase, like say merchandise to a grocery owned by the employer, or commodities or other property from another subsidiary or another company owned by the employer. There should be no control whatsoever. So even if you're an employee of, like, say, SM, you can actually spend your grocery in Robinsons if you want to, because SM cannot prescribe or prohibit you from doing so. This is the non-interference in the disposal of wages. Once you're paid, you have the absolute autonomy to spend your money. Whether you spend it for gambling, for prostitution, whatsoever. I'm not saying that's correct, and we're not saying that you should do it, but the employer cannot stop you from doing it because of the virtue of the non-interference in disposal of wages principle. That's under Article 112 of the Labor Code. Second, wage deduction. No employer in his own behalf or on behalf of any person shall make any deductions from the wages of his employees. If ano talaga yung sahod mo for that particular period, there should be no way that shall be deducted by the employer, even if in behalf of another person. Even if that person is your creditor. Di ba, may utang ka for that person cannot compel the employer to reduce your salary as an advance payment of your particular debt or obligation. But again, labor law, there will be exemptions. Exemptions is when the workers is insured and with his consent by the employer. So that could be insurance deductions. For union dues, like say you're a member of the union will have an agreement with the employer that the dues paid to the union, your union dues will be deducted from your salary. That is a valid deductions. And then third will be in cases where the employer is authorized by law or regulations. So ano yung mga authorization by law or regulations that allow the employer to deduct from the salaries of the employee? SSS, Pag-ibig, PhilHealth, and withholding taxes by virtue of withholding taxes on compensation. So those are deductions from the salaries. They're contrary to the general rule, but they are exemptions that are allowed. So they are valid wage or salary deductions. Third is prohibition against deposit requirements. While deductions from the employee's wages or salaries may be made for cash bonds or deposits, the employer, however, is not allowed to unilaterally impose upon its employees the giving of cash bonds or deposits. But there will be exemptions to these if they're engaged in trades, occupations, or business where the practice of making deductions or requiring deposits is recognized. So I think one example here will be if you're working for, say, deliveries, for like JNT delivery, like some sort of affiliated with shopping apps or e-commerce, because you will be receiving payments from the customers and you'll be handling cash way beyond your salary level. So you were asked to actually make a deposit in order for you not to forfeit the deposits should you decide to renege, running away because you have more cash than your actual salary. Because you will be handling cash here because some are cash on delivery or COD. That the cash bond or deposit is necessary or desirable as determined by the Department of Labor Secretary in appropriate rules and regulations. So there are certain industries, trade, where the employer needs security from the employees because the employees will handle valuable stuff, like say valuable equipment or valuable or cash, for example, handling of cash. So in order to make the arrangement more secure, then the employees are required to make certain deposits. And fourth provision on withholding of wages, it shall be unlawful for any person to withhold any amount from the wages of the worker. But an exemption, employer usually withhold the release of last salary and benefits of terminated or resigning employees prior to compliance with a certain clearance procedure. So there should be a clearance procedure that shall be implemented. Once the clearance has been cleared, then you can already send the final pay to the workers or employees. So you can withhold that one on the condition that there is clearance for the departing or resigning employees. And other prohibitions, we have 4 here: inducing a worker to give up any part of the wages by force, stealth, intimidation, threat, or any other means whatsoever without his consent. That's not allowed. Obviously, you'll see therefore stealth, intimidation. Those are factors that made it illegal to make deductions from wages for the benefits of the employer or his representative as a consideration of a promise of employment, meaning the employer promised you of employment, but a part of your first month's salary will be retained and will be given to the employer or someone else's. That particular reward for you to be hired should not come from your salary, but it's more of like a separate scheme by the employer. There should be like an award scheme, like a referral fee to be paid to the successful referring employee or someone else who referred you when you were hired. But that particular referral fee should not be deducted from your wages or salaries. Refusal by the employer to pay or reduce wages or benefits in discrimination of any employee who has filed any complaint or instituted any proceedings under the labor code or has testified or about to testify. So this is more of a penalty, like retaliation to the employee that should not be allowed. And unlawful or for any person to make any statement, report, or record filed or kept pursuant to the code, knowing that such statement, report, or record to be false in any material aspect. Right? So those are other prohibitions that should not allow for any reduction on the wages of the employees. Now we have arrived in the topic on minimum wage. So we have 2 types of minimum wages under under the labor code, and the other one is statutory one, which is another law. The statutory one or the statutory minimum wage is actually the lowest wage that has been fixed by law that an employer can pay his workers. The compensation, which is less than the minimum wage rate as provided under the law, the statutory minimum wage, is considered an underpayment, which is a violation of the law. Then we also have what we call the regional minimum wage, which is the lowest amount that an employer can pay the workers, which is fixed by the Regional Tripartite Wages and Productivity Board. The regional minimum wage should not be lower than the applicable statutory minimum wage. So while we have the statutory minimum wage, it's supposed to be the lowest, each region will then have its own regional minimum wage, which cannot go lower than the statutory minimum wage. In other words, we have the floor here, which is the statutory minimum wage. That's already the maximum, the lowest that you can actually pay. So going down the statutory minimum wage is tantamount to underpayment, which is a violation of the law, which is illegal. And then each region will then have a regional minimum wage adjusted based on inflation and the cost of living in recognition of the uneven cost of living in each region of the country. So the national capital region could be more expensive, so they would have higher minimum wage than, say, other cities in the country or other parts of the country. The purpose of minimum wage law is to set a barrier below which wages may not fall in order to develop competition on a high level of efficient rather than competition on a low level of wages. The minimum wages must be fair and just, and the minimum wage can by no means imply that it should actually be just the minimum. Some margin or leeway must be provided over and above the minimum to take care of other contingencies such as increase of price of commodities and increase in wants, and to provide means for a desirable improvement in his mode of living. So now we're done with minimum wage. We will now proceed with the actual basic pay. So in this particular topic, we will learn how to compute for your basic pay. We'll know what comprises basic pay and to compute the basic pay of the employees, considering now our understanding on hours of worked and minimum wages. So for basic pay, it includes all remunerations or earnings paid by the employer to an employee for services rendered, including the COLA or the cost of living allowances. However, take note that the basic pay does not include allowances and monetary benefits which are not considered or integrated as part of the regular or basic salary. What are examples of these allowances and monetary benefits? Well, cash equivalents of unused vacation and sick leave credits are not part of the basic pay. Also, your overtime pay, the premium pay, the night shift differential, holiday pay, and commissions. So when you say basic pay, it's literally the basic pay. It's without all the other trappings of allowances, commissions. But take note that basic pay includes cost of living allowances. Right? Now, the modes of payment of your basic pay could either be monthly, daily, or hourly. The basic salary refers to the monetary amount that is paid to an employee, excluding now again all bonuses or deductions from absences or incurred late minutes. So when you compute for the basic pay, it's your basic pay, and then the employer will account now, say, under time, absences, and other deductions, and then they will add now the bonuses in order to compute for the amount to be given to the employee. The basic salary serves as the basis for the computation of the employee's daily rate. So when you compute for the daily rate and the hourly rate, you will stick with your basic salary. So why do we need to compute for the daily rate and the hourly rate if you are paid monthly? It's because we have to measure the daily and the hourly rate on account of your absences and undertime. Say you're fixed paid for the month, but you committed or you incurred an absence for, like, say 2 days, then we will then have to find a way to compute for the 2 days that you were absent to be deducted from your basic salary. So how do we come up with that? Obviously, since you're absent for 2 days, you should be deducted with the amount equivalent to 2 days. And therefore, we have to know how much is the daily rate. And then if you have an undertime of, like, say 4 hours, which is not really the entire day, then we should know how to compute for that 4 hours to be deducted from your basic salary. Hence, it is imperative to know also the daily rate. So daily rate refers to the amount any employee earns for each day worked, whereas monthly rate represents the employee's fixed salary for the entire month. Now, in the next or the succeeding topics, we will learn how to compute for your daily rate and hourly rate, which will be significant and important in the computation of your actual basic pay on account for any absences or undertime, as well as determining now your overtime pay, because that will be hourly as well, and your holiday premiums, because they're on a daily basis with the premium following the rules on premium computations on different types of holidays. Take note that in fixed monthly salaries, the daily rate will only be primarily compute or used to compute now your overtime pay, rest day pay, holiday pay, and other forms of additional compensation. Okay? Now, to compute for your daily rate, the daily rate is actually basic monthly rate. You multiply it by 12 months to get the entire annual rate and divided by the total working days of the employee. So how do we come up with the total working days? You deduct the number of weekends or Sundays or day offs of that particular employee and deduct also the number of regular holidays as provided under the labor code. So for those working from Mondays to Saturdays, the total working days will be 313 days. And those working or employed from Mondays to Fridays, the total working days will be 261 days. Let's proceed to the illustration. So for example, if the basic salary is 25,000 and the worker or the employee is working from Mondays to Fridays, it will be 25,000 times 12 months. That will be 300,000 in annual income or annual salary divided by 261 days, and that will come up with 1,149 pesos and 43 centavos as the daily rate of the 25,000 fixed monthly salary of that employee. So again, the 25,000 monthly salary of an employee that works Mondays to Fridays will yield a 1,149.43 per day rate. And that is way beyond the minimum wage. Right? And also, I'm not going to confuse you with taxation, but the 300,000 annual gross salary is already above the 250,000 threshold for tax exemption. Now, assuming the basic salary is the same, 25,000 pesos, but the worker or the employee is working Mondays to Saturdays, same thing, 25,000 times 12 months, that will give us 300,000 pesos annual salary divided by 313 working days. Again, it's Mondays to Saturdays, so it's a longer work day, and will give us 958 pesos and 47 centavos as the daily rate. So while the two employees will has the same fixed salary of 25,000 per month, the other one will benefit more when there will be an overtime pay or the holiday pay, the one working from Mondays to Fridays, because he or she is paid at a much higher daily rate as compared to someone who works Mondays to Saturdays. Right. Now, let's proceed to overtime pay. It refers to the normal work hours of 8 hours that we have just discussed early on. So overtime is any service rendered in excess or in addition to the 8 hours of the ordinary working days. Overtime pay is the additional compensation of at least 25% of the regular wage for the service or work rendered or performed in excess of 8 hours a day by employees or laborers in the employment covered by the 8-hour labor law. Now, so how do we actually compute for this overtime pay later on? Obviously, this would refer to the hourly rate, which will then be paid with an additional 25%. So the excess of the 8 hours, assuming you've worked for 12 hours, your overtime hours will be 4 hours. That 4 hours will be multiplied by the hourly rate times 1.25. One, because again, you still pay those hourly rate for the hours actually worked. It doesn't mean you pay 25%. You still pay the entire hourly rate plus 25%, so 1.25. So how do we compute for the hourly rate? We go back now, class, or anyone, to the computation of our daily rate. When you compute for the daily rate, you divide it by the number of work hours. So for example, the daily rate was 1,450. You divide it by 8 hours, then you will come up with the hourly rate. Overtime pay is based on the regular base pay, excluding now any money received by the employee in different concepts. So you exclude there like your Christmas bonuses, your other fringe benefits. It's literally just the basic salary. And it is computed by multiplying the overtime hourly rate by the number of hours in excess of 8 and then 1.25. Now, we have different types of overtime rates depending on the situation. So if it's a regular work day, meaning it's just a regular day, and the employee works for more than 8 hours, the additional compensation is 25%. So it's 1.25. However, if the overtime actually happened on a holiday or the rest day, the rate could be a little bit different. So for the first 8 hours, it will be paid on again with a premium rate, considering that it's a holiday or a rest day, and then an additional 30% for the excess of the 8 hours. So if it's in a special non-working holiday or a rest day, it will be multiplied by 1.30 and then you multiply again with another 1.30. So the rate for that particular day is already 1.30, which is an additional 30% premium on account of the special non-working holiday or the rest day. So hourly rate times the number of hours times 1.30 times again 1.30. Okay? Or you get the 30% to actually get the separate overtime pay. Now for a special holiday and the rest day, so both, it will be 30% of a much higher rate, which is already 150% of the regular hourly rate. So the regular hourly rate times 150%, so that's 1.50, times the number of hours, times 1.30 to come up with the total pay for those overtime hours of 4 hours. Now, if it's done on a regular holiday, not both rest day, it's 30% of 200% because it's double paid for those hours. It's because it's a regular holiday. You're already deemed paid for that particular day or for the particular hour, and then you will be paid again for the actual work done, and then an additional 30% in order for us to actually account for the overtime pay. Now, for the holiday premium, the holiday premium is a pay given by law to an employee even if he does not work on a regular holiday. The payment of the regular daily wage for any unworked regular holiday, so even if you have not worked on the regular holiday, you're still deemed paid because of the nature of its being a regular holiday. The premium is given to an employee pursuant to the law, even if he has not been suffered or permitted to work. Again, no need to work on that particular day. But assuming that in a regular holiday you still worked, you will receive additional compensation and that apart from the fact that it's already paid. Hence, it will be paid 200% if it's a regular holiday. Now, the holiday prepay premium of 200% is only limited to the 12 regular holidays, which are also called legal holidays listed by law. The employees should not have been absent, however, as a requirement without pay on the working day preceding the regular holiday. So assuming the regular holiday is on a Friday, so if the employee will not work on a Friday, the employee is still deemed paid because Friday is a regular holiday. However, if that particular employee is absent without pay on Thursday, then that particular employee is not entitled of that regular holiday pay on Friday because he is absent on the preceding day, which is Thursday, and is absent without pay. But assuming there is a valid leave filed on Thursday, the employee still enjoys the regular pay on Friday. It's because while the employee is absent on the preceding day, Thursday, that absence is not without pay because it is a valid leave. Okay? A work leave is a leave with pay. Holiday pay is primarily aimed at benefiting the daily paid workers whose income is circumscribed by the principle of no work, no pay. So prior to the enactment of the Labor Code and prior to the provisions of the holiday premium, the daily paid workers were actually not paid for unworked regular holidays. Whereas the fixed monthly salary people are still paid with that because they're fixed monthly. It's not really an absence to begin with. So the daily wage workers, the daily paid workers are actually in a disadvantage. But because of the holiday premium, they're no longer in a disadvantage because even if they have not worked on those regular holidays, they are still deemed paid by virtue of this provision. The no work, no pay will no longer apply. Now, for the list of holidays, I've mentioned a while ago that there are 12 regular holidays. These are legal holidays provided by law. So we have the New Year's Day, Araw ng Kagitingan, Monday, Thursday, Good Friday, Labor Day, Independence Day, National Heroes Day, Eid al-Fitr, Eid al-Adha, Bonifacio Day, Christmas Day, and Rizal Day. All of these 12 are the regular holidays. So if you work on these particular days, you're actually paid 200%. Then we have the special non-working holidays. These are not, they're outside the 12 enumerated, and they are declared non-working holidays either by the presidential proclamation or your mayor's executive order. These are also holidays. If you work on these particular holidays, you'll still get a premium, but not 200%, but only 130%, a 30% premium. All right, examples of special non-working holidays will be the Ninoy Aquino Day, All Saints Day, the Feast of Immaculate Conception of Mary, and the last day of the year, or December 31. All right. So the special non-working holidays, again, class, is not an exclusive list. They can be expanded by virtue of the declaration of the chief executive, the president of the country, or the chief executive of the locality where you reside or where you work. Now, for the compensation and holidays, for regular holidays, if and worked, you are still compensable, but subject to the conditions. Remember the condition that you have worked on the preceding day, or you are not in absence without pay. But for special non-working holiday, if you don't work on that particular day, it is not compensable. For regular holidays, if worked, the rate is 200%. And for special non-working holidays, it's 130% because you will still be paid on your regular wage. For that particular special non-working holiday, if you've worked, an additional 30% premium. Now, again, the difference between the two, the regular holidays is limited only to 12 days provided under the Labor Code, whereas the special non-working holidays is not exclusive. It can be expanded either by other laws, expanded by executive orders, or other declarations to that effect. Now, for the 13th month pay, the 13th month pay or its equivalent, it's a form of a monetary benefit which is equivalent to the monthly basic compensation received by an employee, which is computed pro rata according to the number of months within a year that the employee has rendered service to the employer. The time of payment of 13th month pay should be done and should be paid to the rank and file employees not later than December 24. So you can actually send or pay your employees ahead, or the employees be paid ahead. So it could be paid middle of the year, and then the half will be paid on or before the deadline, as long as it will not exceed the 24th of December every year. So on or before December 24, you can already receive your 13th month pay, which you can now use to defray expenses for the holiday celebration, which is basically the purpose of the 13th month pay. So to compute for your 13th month pay, you will have then the total basic salary earned during the year, which will then be computed based on the pay slips accumulated yung entire 12 months na receive ng employee. So that will account now for, say, absences, for holiday pays, and everything. And then the total basic salary will then be divided by 12 months, which will then be distributed as a 13th month pay. So the minimum period of service required, it is imposed, an employee have worked for at least a month during the calendar year to be entitled for the 13th month pay. Republic Act number 1036-1 is now explicit in its commandment that a domestic worker or kasambahay is entitled to 13th month pay as provided by law. Now let's proceed to service incentive leave. It's a 5-day leave with pay for every employee who has rendered at least 1 year of service, whether continuous or broken. So the moment you've exceeded or you have at least rendered 1 year to the employer, you're already entitled to the service incentive leave, which is a 5-day leave. The stipulation in the contract for an allowance of a vacation to employees is a recognition of the management and labor that a short interval of complete rest and relaxation from daily routine with the benefit of full pay is essential to the mental and physical well-being of the workman. That was the ruling of the Supreme Court in Benshaw versus Joseph Buda, a a case in, no, I think that's the US case, as well as Sunripe Coconut Products versus NLU, which is an old case as well. So basically here, it's a recognition of the importance of service incentive leave in the maintenance of or upholding of the importance of the mental and physical well-being of our workers. Now, for the right to service incentive leaves, take note that every employee who has already rendered 1 year of service is entitled to the yearly service incentive leave of 5 days with pay. The leave pay means an employee gets paid despite of that particular absence. Exemptions to this right to service incentive leaves obviously will be the similar individuals who are exempt from the coverage of the labor code, the government employees, whether employed by the national government or any political subdivisions like the LGU, the province, the municipality or cities, including those employed by government-owned and controlled corporations, the domestic helpers and persons in personal service of another, the managerial employees, field personnel, and those whose time and performance are unsupervised by the employer, those who are already enjoying that kinds of benefits, so those granted already with like say 10 leaves, they no longer have to exercise the service incentive leaves because those kinds of benefits are already above the 5 leaves being granted or being prescribed under the law. Those enjoying vacation leave with pay, which at least 5 days, but if the employees are enjoying 3 days of leave from the employer, they can seek refuge under the service incentive leave provision to ask for additional 2 days in order for them to reach the minimum requirement of 5 service leaves per year if they have already rendered the 1 year service. And the last exemption will be those employed in establishments that are regularly employing less than, I think, 10 employees. Okay. Now, for expanded maternity leave, this is the leave that applies to all qualified female workers regardless of civil status, employment status, and legitimacy of the child. Now, the maternity leave presupposes that there is actual pregnancy. So I'm not sure how the law will treat now if we will now reach to the point of we are recognizing transgender women as actual females, and if there are workers, there are female workers of the company, they will be allowed for the expanded maternity leave. But again, the expanded maternity leave presupposes that there is an actual pregnancy. Under the law, the maternity leave applies to all qualified women or female workers in the public sector, private sector, informal economy, voluntary contributors to the SSS, and national athletes. Take note that informal economy refers to self-employed, occasionally or personally hired, subcontracted, paid and unpaid family workers in the household, incorporated and unincorporated enterprises, including yung mga home workers, micro-entrepreneurs, and producers and operators of sari-sari stores that was provided under Republic Act number 11-21-0. Now, what are the benefits under the expanded maternity leave? Under the expanded maternity leave, paid leave benefit were granted to qualified female workers in the public sector for the duration of 105 days with full pay for live childbirth, regardless of the mode of delivery, so whether it's normal delivery or cesarean, but an additional 15 days paid leave if the female worker qualifies as a solo parent under the Solo Parents Welfare Act of 2000. Now, it will be 60 days with full pay if it's not a live childbirth, meaning it's a miscarriage or an ETP or an emergency termination of pregnancy. The miscarriage and emergency termination of pregnancy is defined under Republic Act number 11-21-0. Miscarriage refers to pregnancy loss during the 20th week of gestation, while ETP or emergency termination of pregnancy refers to pregnancy loss on or after the 20th week of gestation, including stillbirth. An option to extend for additional 30 days without pay in case of childbirth, again, provided that the employer shall be given notice that it must be in writing and it must be given at least 45 days before the end of the initial maternity leave of the female worker. There will be no prior notice is necessary in the event of a medical emergency, and a subsequent notice to the employer shall be sufficient. The paid leave benefit granted to a qualified female worker in the private sector will be covered by the SSS, including the informal economy. Health care services for prenatal, delivery, postpartum, and pregnancy-related conditions to female workers, particularly those who are neither voluntary or regular members of the SSS, are governed by the existing rules and regulations. Regular members will be governed by the existing rules and regulations of PhilHealth. Now, what will be the manner of enjoyment of the expanded maternity leave? The expanded maternity leave cannot be deferred, meaning you cannot, like, say, not avail it. Okay, you can either avail it before or after the actual period of delivery in the continuous and uninterrupted manner, not exceeding 105 days. You cannot also defer it, that you can just use it later on once you decide after giving birth. It should be either before or after the delivery of the actual baby. The maternity leave can be credited as combinations of prenatal and postnatal leave. So it could be the one part of the 105 days will be before the delivery, and part of the 105 days will be after the delivery, provided that the compulsory postnatal leave shall not be less than 60 days. So minimum 60 days ang postnatal. So by maximum, you can only spend around 405, the 105 days sa prenatal leave. Take note that the maternity leave shall be granted to qualified female workers in every instance of pregnancy, miscarriage, or ETPs, regardless of frequency. Now, for paternity leave, it refers now to the fathers. It refers to benefits granted to married male employees, allowing them to provide support to their wives who've given birth. Wife, I mean, because obviously it's only one wife under the laws. If you have multiple wives, and you're not one of the exempted ones, you'll probably be bigamous. But, if you only have one wife, you allow you to report for work 7 days, but to continue to earn compensation on the condition that your spouse has delivered a child or suffered a miscarriage, for purposes of enabling you to effectively lend support and a period of recovery and nursing your newly born child. In the event that the paternity leave benefit is not availed, it's not convertible. So you should rather avail it, right? So it's a non-commutation of this particular benefit. So what are the conditions in order for a male worker or an employee to be entitled to paternity leave? First, he must be married. He must be married at the time of the delivery of the child, and he's living or cohabiting with that particular spouse at the time of giving birth, or the wife suffering miscarriage, and he has applied for paternity leave within a reasonable period of time from the expected date of delivery of the pregnant spouse, or within the period provided by the company rules under the collective bargaining agreement or CBAs, should there be a union. The wife has actually given birth or suffered a miscarriage. So, for example, if the male worker's mistress gave birth, the male worker cannot avail the paternity leave because the one who gave birth is not the wife. Okay? So, again, it must be the wife. For parental leave for solo parents, on the other hand, these are leave benefits granted to a solo parent to enable him to perform, or her to perform, parental duties and responsibilities where physical presence is required. The parental leave for solo parents will not exceed, again, 7 working days, and shall be granted to those, again, employees, and the qualification will be those who have rendered 1 year service. It should be noted that in this particular leave, the legally mandated leave, the service incentive leave, the SSS sick leave, the SS maternity leave, and the paternity leave are not counted inclusive with this one. So they are in addition to these legally mandated leaves. So these are given as an addition to solo parents because, the child might have a school activity. So the solo parent can use the parental leave for solo parents to actually attend these school activities, because no one can actually attend on his or her behalf, because again, it's a solo parent, single. Whereas for married couples, you don't have this one, because you can either use your other available leaves, and you can alternate with each other, right? So here with solo parents, if they cannot attend because they run out of leave, then the child will be left with no one to actually watch their school activities. So that would be quite sad. So this is in recognition of the quite disadvantage of many solo parents with respect to, like, say, married parents. Okay. Now, for the conditions for the entitlement of the parental leave, the solo parent has rendered at least 1 year of service, whether it's continuous or broken. There is notification to the employer of the availment of these solo parent leave, and he or she has presented a solo parent identification card to the employer that will be obtained from the Department of Social Welfare and Development Office of the city or municipality where the solo parent resides. Okay. So those are the like an overview of the labor law in the Philippines, covering topics ranging from hours of work, employee-employee relationship, the coverage of the labor code, our basic pay, overtime pay, premiums, our holiday pay, as well as the different types of leaves that employees can actually avail and enjoy while working here in the Philippines. So if you have any questions, you can email us at shalumiel.abapo@davoaccountants.com. You can also check my social media accounts, Twitter and Instagram at Shalu Abapo. You can also check my Facebook page, Shalu Abapo, for any questions or clarifications. You can hit the subscribe button for you to be notified of any other topics that I will upload in the coming months, this 2024. So thank you for watching. Good day.